Hi, my name is William Webster, and I'm an attorney at Webster Garino, which is a law firm located in Westfield, Indiana. And I wanted to talk to you briefly about an interesting case that we had that really is applicable to anybody that owns a cell phone or electronic device. And it brought up an interesting issue as to whether law enforcement can compel someone to provide their password or to unlock their electronic device. So to give you an example, if you were pulled over or arrested, could law enforcement then again, require you to provide your password so they could search your phone to look for incriminating evidence to be used against you in your criminal case. And so we took the position and we argued that an individual cannot be compelled to provide their password to their cell phone or to unlock their electronic device. And that violated their Fifth Amendment protection against self-incrimination offered by the United States Constitution. So in our case, again, our client's name was Caitlin Saul. Last name was spelled S-E-O. And it's important to give you a little background briefly to kind of set the case up for you. But in July of 2017, she was arrested for intimidation, harassment. And a couple months later, she was arrested again for violating a protective order. It's also important to note that while after she was arrested, she was also being investigated for other crimes related to the same individual and also an unrelated third party. So about a month later, the state of Indiana sought a search warrant to compel my client to provide her password or to unlock her cell phone so that the state could do a forensic download and search all its contents for incriminating evidence. And why this is so important, if you can take a minute, just imagine all the data that's on your cell phone. Yeah, from what phone calls you're making, pictures of your family, communications with your spouse or your loved ones, emails, web browsing history, GPS location, Facebook, Twitter, any type of social media accounts, all that data is stored on your phone. And so by allowing the state or forcing an individual to unlock their phone so the state can have carte blanche in looking at the contents of their phone, it provides a tremendous amount of information and data that could lead to incriminating evidence to be used against someone. And again, we think that's a clear violation of an individual's civil liberties. And so again, to continue on with our client's case, at the trial court level, the trial court found that our client had to unlock her phone. In order to do so, or to report to jail essentially indefinitely. We filed a motion to stay that order, meaning to put a pause on that order while we appealed the case to the Indiana Court of Appeals. And that case is Caitlin Saul versus State of Indiana. The Indiana Court of Appeals overturned the trial court and found that our client, by requiring our client to provide her password or to unlock her phone, did violate her Fifth Amendment privilege provided by the United States Constitution and also the Indiana State Constitution, Article 14, which indicates that a person can't be compelled to testify against themselves. The state of Indiana filed a transfer to our Indiana Supreme Court, which was accepted by the court, essentially that at that moment that it vacates that Indiana Court of Appeals order. The American Civil Liberties Union, the ACLU, and the Electronic Frontier Foundation filed amicus briefs on our behalf, meaning a brief in support of our position. We had oral arguments in the spring, and we're currently waiting a decision from the Indiana Supreme Court, which we hope will come here in the coming months. And so I'm going to give you a general overview of the legal arguments, and in no way is this meant to be an in-depth or to cover all the topics. So if you'd like to have some more information about the case, I'm going to try to leave some links of some of the cases I'll be citing, and also a link if you want to watch the oral argument. So in order for our client to invoke her Fifth Amendment privilege, she must do three things, or show three things. We must show there's compulsion, that it's testimonial, and that'll lead to incriminating evidence. The first one, compulsion, I don't think there's much argument our client's being compelled to do something. We have two warrants compelling our client to unlock the phone and also so the state can do a forensic download. We have a trial court order saying our client has to do it or she has to go to jail indefinitely. So I don't believe anybody's arguing that the element of compulsion is met in this particular case. Now, whether the act is testimonial, there's some argument back and forth on this particular element. So our position is whether it's speaking, whether it's providing the password, or it's an act, as far as manually entering the password, that both are testimonial. And we have Supreme Court decisions that support our position. Two in particular are Doe versus United States, Doe 2 versus United States, and also Hubble versus United States. And in those cases, the Supreme Court has said that even the assembly of documents, the act of assembling documents, was testimonial. And the reason being is it communicates three things. Those documents exist, they're under the individual's control, and they're authentic. So to give you an example, so if the government or law enforcement requires me to produce documents, in that case, they didn't identify with any reasonable particularity what documents they were looking for. It was just kind of a broad subpoena. So then if I'm compelled then to produce those documents, I'm communicating that they exist because the government didn't know they existed. I'm communicating that they're authentic because they're my documents and I prepared them, and that they're under my control. And so even an act can be testimonial. So again, I think that second prong of the test that we meet here too, because again, if my client speaks it, clearly that's testimonial. If she's required to perform an act, that can be viewed as testimonial. And because that act, again, communicates, if she's, that act of unlocking the phone communicates to law enforcement that all the information on her phone exists, that all the information on her phone is authentic, and all the information on her phone is under her control. And again, if you think about the tremendous amount of data that's on the phone, again, that's why this case is so important for anybody that owns a phone or electronic device. So once we meet those three elements, then the state made an argument that we should apply the foregone conclusion doctrine. Foregone conclusion doctrine comes out of the case of United States versus Fisher. And what that foregone conclusion doctrine basically states is that if the government already knows, or if law enforcement already knows that something exists, then it's a foregone conclusion, then the individual adds very little to the state's case. For example, in the Fisher's case, there were tax returns that were prepared by an accountant that were being held by the individual's attorney. The government sought, via subpoena, those tax returns. The individuals invoked their Fifth Amendment privilege against self-incrimination. And the Supreme Court, and again in Fisher, indicated that these documents, was already a foregone conclusion that these documents existed. The accountants prepared them. They weren't even prepared by the individual. They were being held by the attorney. So by producing them, the individual added very little to the state's case, the government's case. So again, this case is, what's interesting is as I'm making this video, I'm aware of no United States Supreme Court cases where the court applied the foregone conclusion doctrine to testimony. And why this is important, anytime we're talking about the foregone conclusion doctrine, it's always been dealing with documents. We already know those documents exist. So by you producing them, you add very little to our case. But by applying it to testimony is, I think, a very kind of slippery slope and potentially threatens, again, these Fifth Amendment privilege that I earlier spoke about. And what I mean by that is that if we apply the foregone conclusion to testimony, then essentially the state can say at any point in the case that we already know you know this. Or we saw the surveillance video. We knew where you're at the night of the incident. And so therefore we can compel you to tell us where you were that evening, or any other fact about a case where the government can try to basically assert that they already know the fact, and then so can compel you to speak, to testify. And so again, I think it's really important that at least our argument was that this is a misapplication of the foregone conclusion doctrine, and foregone conclusion doctrine should not be applied to testimony. And further, there's no foregone conclusion that anything on my client's phone existed. I think the state believes that there could be something. They think there's something. And so they want to go on a fishing expedition to look for potential incriminating evidence to use against my client. The other interesting, I think, argument about applying the foregone conclusion to my client's password is if the state already knew my client's password, therefore making it a foregone conclusion, then there'd be no need to compel her to provide it. So again, I think it's a misapplication of the foregone conclusion doctrine, and we're hopeful, at least, that the Indiana Supreme Court agrees with our position. That by making an individual provide their password to unlock their electronic device, then not only is a violation of the protections in our Indiana State Constitution, but also against the United States Constitution. So again, I hope you found the information useful. Again, if you'd like to know more information, I'm going to try to provide some links at the bottom of some of the cases I cited, and also a link to the oral argument if you want to view that yourself. So again, my name is William Webster with Webster Garino. Again, we're a law firm in Westfield, Indiana. And certainly if you have a similar issue come up, feel free to please contact us immediately before talking to law enforcement, or certainly before you provide your password, and so that we can advise you accordingly. So again, hope you found this video helpful, and thanks for watching.